Hello everyone, Daniel Gaines here. Was asked recently about what's going on, so I figured I'd hop on real quick and give a brief update. Currently, we are going to the Court of Appeals. The notice of appeal has been filed, filing fees have been paid, the statement of arrangements for the transcript, the record from the clerk, it's all been requested. I'm just waiting on that now. 60 days is up December 6th. So once I get those records and everything, which should be any time, but once I get those, then I will put together my appellate brief, and whenever I get my brief done, that I will post a video of and show my appellate brief. Excuse me, I won't be able to go over everything in it because of time, but I will at least show all the pertinent and relevant information. I'm having 2 filings of mine and one of the 2 transcripts submitted to the appellate court. Yes, it really would be best to have the entire record submitted. However, these 2 filings have more than enough evidence, more than enough case law. The case precedent is in it. Legal codes and all that are in it. So I'm only using a partial record, and I'm going to utterly destroy the state courts at the appellate level. I'm also going to question and ask, because I'm going to request it be on the record, the hearing, oral arguments, rather, not on the record, but oral, the appeal anyway. I'm also going to question if the appellate court in the state of Washington has ever been sued for intentionally overly complicating things to try and prevent pro se parties from being successful in filing an appeal. So, and then I think I might include that in the legal action I'm dealing with the state of Washington. I don't know yet. That's small fries compared to everything else, so it's really not the end of the world. But they shouldn't intentionally overly complicate things, trying to prevent people and black people from appealing anything. Yeah, I mean, really, that's where it is. The appellate process takes time. It's not quick. When you file your notice of appeal, you have 60 days to get the record and everything, the transcripts and all that shit done. And then once that time frame's done, or whenever you get everything submitted, then it goes to where you have your 45 days to do your appellate brief. And then after that, there's a few more steps and blah, blah, blah. An appeal is a process. However, I've got other things I'm doing as well. I'm maybe a week to 2 weeks out from filing legal action against the state of Missouri, against child support in the state of Missouri. I'm not filing any kind of child support, anything in the state of Missouri. I'm just filing an actual a lawsuit against child support for their threats and harassment and yada, yada, yada. I'm not going into the RICO, the racketeering, extortion, bribery. I'm not going into the conspiracy against my rights and to deprive me of my rights between the state of Missouri and the state of Washington. All that'll be for the federal courts. I'm just going to sue them initially for threats and harassment in small claims court, seeking the max. I'm doing this way because, for one, it'll stop them trying to bother me while I'm filing this insurance claim, the injury claim. Car accident I was not at fault for. Only car accident I've ever been in my life when I was driving, in fact. Somebody hit me. But anyway, I digress. It's going to serve dual purposes. A small claims suit will be heard in a shorter amount of time than the appeal. So by the time the oral arguments for the appeal are actually heard, I will already have and be able to include on the record a court order from the state of Missouri showing that, yeah, those orders are in fact void, or at least the courts in Missouri found them to be void. So it'll help the appeal, it'll strengthen that. Plus, it also sets the stage for the bigger federal action. Because when I beat the state of Missouri, which I'm going to, y'all all see that because it'll be live. Everything will be posted like it always is. When I beat them at the state level, it'll give them, I'm going to mention how I'm not bringing up any of the massive stuff that's the damages are substantially higher for. I'm going to mention that I'm not including any of that at this time because all that will be going to the federal lawsuit whenever I file my federal lawsuit, including the conspiracy with the state of Washington. And it's already proven Missouri's trying to enforce a void order at the behest of the state of Washington. That's conspiracy, period. Look it up under the law. Anyway, in doing this, the Office of Attorney General is already going to be involved in the lawsuit against child support. So they're going to be aware of the other things that I'm going to be bringing to the federal courts. So I will give the Attorney General of the state of Missouri an opportunity to discuss settling this without it going to court. If they're smart, they'll do it. If not, they'll pay a lot more. But see, it's not necessarily about Missouri, though. Everything is being done for a reason the way it's being done. It's all going to crescendo, and it's all on the last steps right now. After the appeal, there is nothing left except the federal lawsuit. And it's coming. And the beauty of it is, seeing as everything that was done, the dependency and all of it was all done, all derived from void orders, there is no statute of limitations. There is no time bar. There is no time barrier. I can wait 50 years to file. No, I'm not going to. It'll be filed in the next 6-8 months. At most, the federal lawsuit will. Because at the latest, January, February is when my appeal should be heard. So we're 6-8 months away at most from the federal filing. And then at which case, and at which time, things really get fun. Because see, y'all have seen what I filed. Y'all have seen the evidence I filed. Y'all have seen the lack of everything from anybody in the state of Washington. Now y'all about to see me go on the offensive. I've been playing defense all this time. Because that's the way it's got to be. You have to go on defense before you can go on offense. You have to secure your perimeter before you can start expanding, so to speak, right? And all the defensive stuff and postures is done. Now that I've got this appeal going, it's time to start opening up these avenues of attack. And the first one's going to be the state of Missouri. I don't mean attack as in any kind of harm to anybody or anything. I just mean attack as in I'm filing. Instead of filing like modifications or filing in response, I'm actually going to start initiating legal action. That's what I mean when I say attack. So, the plan is, any day now, I'll be filing, any day within the next week or two, I'll be filing the lawsuit against the state of Missouri, child support, and only child support. And then things will go from there. It's about to get interesting, y'all. Told y'all it's coming. They fucked with the wrong one. They were warned. They were told. They were begged, they were pleaded with, they were asked, they were warned. They were even threatened with the lawsuits. They decided to play games. Well, play stupid games, win stupid prizes. So, as for me, that's all I got right now. I know a bit anticlimactic right now. However, things are coming. Y'all will see the filings as I write them out right after I file them. Y'all will see it. Again, my next filing is not far off, and it'll be against the state of Missouri, and it will benefit in the state of Washington. But as far as the state of Washington goes, sadly, the appellate process is a slow one. And that's at best for anybody. It's never going to be quick. There are time frames that they have to give, like the court reporters and all that stuff. They have to give sufficient time for the appellate brief to be done and all that. So there's again, and sadly, there's really nothing that can be done. So, but everything's been filed. Everything's been submitted. I'm just waiting on everything to come in so I can serve it to Downing. Yeah, and this clown said he was done with everything. There's no reason he would need to deal with the Court of Appeals because nothing was going to get done, blah, blah, blah. Hey, Downing. You still think nothing's going to be filed with the Court of Appeals? The record will be paid for. Everything will be paid for this Friday, bud. That's right. It all gets paid for Friday, which means start working on your brief, bud. And this time, you better try to find some laws or case laws or something, because you're a star in my brief as well. Told you I'm coming for your career. Told you I'm coming for you too, since you want to play fucking games. You didn't want to listen? Well, it's your fault, you dumbass. You were told you were outclassed by me. You were told you couldn't fucking hold a candle to me. You were told you will never be as knowledgeable in this area of law as I am. You were told all these things. You've been beat in every court hearing. You just rely on the fact that I'm pro se and you've got a bar number. And you rely on the fact that the corruption is deep in the state of Washington, so everything's predetermined. An appeal's not. Neither's a federal lawsuit, bud. You don't have any weight there. Fuck you, Downing. Fuck you. I'll see you in the appeals court, you bitch. The rest of you, peace out. Love y'all. Have a good one.